Hi, this is Michael Cohen. I'm a Dallas elder law and estate planning attorney. I'm joined by my good friend, Don Crawford Jr., who I did a radio show with for many years, and now we're just continuing with podcast as we kind of like we've done in the past. So, Don, today's topic is going to be about a signature card at Merrill Lynch, quite frankly, where there was a married couple and whether the X on the where it said JTWROS was sufficient for it to go to the survivor. All right, so let's kind of talk about this, whether this X alone, without any initials, was sufficient for it to go to the survivor. Because if it was just a joint account, in this case, the couple was married, but they had children from a prior marriage and they each had their own will. And with a will, if it's just a joint account, a lot of people don't realize this. If it's just a joint account and somebody dies, it doesn't go to the survivor.
Right.
That community property interest or would go to according to that person's will. And in this case, the wife's will says everything to her children. But if it's joint with right of survivorship, then it goes to the survivor, whoever the survivor is. Well, in this case, um, Merrill Lynch had a couple different forms, one with just the different types of joint accounts. Joint, joint with rise survivorship. The various types. There's about five different types of joint accounts, surprisingly enough. Anyway, so there was an X where it has JTWROS or JROS. Sometimes it's one way, sometimes it's the other way. Anyway, the children of the deceased spouse said that was insufficient because there was not, first of all, any initials, and it wasn't maybe even the handwriting of either spouse with that X. And furthermore, they said there's no definition. How are they to know that that was just going to go to the survivor?
Right.
So they went to court to say it should just be either a joint asset, so they would inherit that money or that half that money. Well, so the jury decided against those children and it went up on appeal. Now, why did they determine? Let's hear some more facts. They said there might have even been another form that didn't have any X at all. And they had a handwriting expert, and they said that's not their signature. Well, that may be true, but what the jury also listened to, as approved by the appellate court, that first of all, that Merrill Lynch, even if they didn't do that, they have a different form that says what the definition of a joint with right of survivorship account is. It goes to the survivor. And they signed this other agreement. Second of all, they said, well, um, even if they didn't sign it, Merrill Lynch's policy is if some advisor initials does it for them, they can do it for them at their direction.
Fair.
So it must have been at their direction. The husband thought it was supposed to go to the survivor, but he has dementia now. And so this is a relatively recent case. And so, but he thought it was going to go to the survivor, but of course he has dementia, so it's not set in stone.
Right.
And second of all, so they have this policy. And third, when you get your bank statements, it says joint tenants with rise survivorship. And this accounts, oh, this was done 20 years ago. So they've been getting statements all along that says it's a joint with rise survivorship. It can be signed, they signed something else that talked about the definitions, even though that particular form didn't define it. And even if they didn't put their own initials by it, it was done. And if somebody else signed it for them, it could be done at the direction under their policy. So after the jury determined that it should go to the survivor, the appellate court agreed with the jury. There didn't need to be a separate agreement signed by both of them for each because they thought it was sufficient evidence that it should go to the survivor.
Okay.
I think there's a moral to the story here. First of all, you better look at what you're signing and make sure it's clear.
Really.
And I think a lot of times people don't realize just because it's a joint account, it necessarily goes to the survivor.
Right.
Most of the time, quite frankly, nobody complains and the joint account owner gets the money. But in this case, the kids either got an attorney or knew that a joint account without a right of survivorship account could go by the person's will. So I think most people are not aware of that. And so this is a important lesson for a lot of people to know because we see that part on a daily basis that people are not aware of that.
Going back to your first caveat, where make sure that you sign it correctly, you do everything correctly. I watch the datelines at times and I see these attorneys for the prosecution or attorneys for the defendant. What do you think is going to happen? And they still don't know. And they could think it's a shoo-in. They still won't say, but you never know with a judge and a jury or a jury what's going to happen and how they're going to decide in the end. And this is the same thing in this case. Who needs that stress? Just do it right the first time, as you're implying.
Yeah, it's what you said too just a second ago is true. I mean, I was thinking about the show that we did recently about Brendan Storesby. And we said everybody was shocked when the judge said, "Yeah, you could play football. It's okay. We'll suspend it because of your health condition." I think a lot of people were shocked about that, and probably some of the Supreme Court decisions that were made at the end of June. Some people probably were surprised by some of the decisions there as well. So you're right. You never know. Some of the things that we thought have been precedent even for a long, long time are no longer precedent. So you never know what a judge or jury or Supreme Court even will do. So all you could do is be best prepared to protect yourself the best way you can, at least know what you're doing, but when you do it.
I've always said air beware, and this is what you're talking about, and the air needs to beware so that they do the right thing diligently, assiduously, and they make sure everything is crossed, every T is crossed, so that they can fulfill their part and not have to deal with the stress later. One way to do that too is to also attend your next workshop to make sure that all their T's are crossed.
Yeah, I mean, we have free workshops every month. It varies from time to time. But if somebody wants to attend the free estate planning essentials workshop, then all you have to do is call 214-720-0102 or sign up online at dallaselderlawyer.com. We ask people what they want to know, and for 2 hours we talk about. Nobody's ever asked about a joint account or joint versus joint with rise survivorship that I can recall. And we've been doing these for oh gee, probably 14, 15 years. Anyway, we ask people what they want to know, and then we answer those questions. Do have a presentation, but in any event, we try to make sure that your questions are answered.
See, what I
Again,
would do though, if I heard you talk about something like that, where you tell us all that no one brings up these questions to the workshop, that then occasions me to conclude that you are bringing up extreme cases, but that in the epicenter, in the sweet spot, you deal with that all the time. And therefore, you know, like the back of your hand. And if my situation is normal, that you'll get this done with no problem now or when I pass away.
Yeah. Yeah. I mean, there's different planning, and usually on the questions, even though the questions are different at every workshop, we've usually seen them before. So,
Right.
but in any event, yeah, if you want to, the whole idea is to to protect your things the way you want, under the terms that you want, to make it as easy as possible for your loved ones, under the terms and conditions that's best for you while you retain control during your lifetime.
Great. Very good.
All right. Well, Don, until next time,
Thank you, Michael.
thank you.